Stop. Come on. We're about to go. Hello, welcome to our show, Crooked Doctors. Today is Friday, November 4th, 2011, and we have a caller who's waiting to talk to us, but hello caller.
Hello?
Okay, I'm going to give our brief summary statement before we talk. Can you hear me good?
Yes.
Excellent. Now, this is Mr. Keith LeBeau. You want to say hello?
Hello, Mr. LeBeau.
How you doing?
Good, good.
Okay, so here's the brief summary statement. On the phone we have Ozana Radin. She's my mother. I talked to law enforcement. You know, the purpose of this show is that to put facts on the record. If I could do this in a court, I would, but because I'm being shut out of the courts, the strategy is if you can't be heard in the courts, be heard everywhere else. So I talked to law enforcement this week, and they asked for a timeline. So with as much supportive information and evidence as I possibly could collect. So are you still with us, caller?
Yes.
Okay,
yes.
Stay there, caller, because we're going to do the brief summary statement. So in April of 2007, my mother, Ozana Radin, went down to speak with Judge Robert P. Patterson, Jr., who is in a district court judge. This is Southern District of New York, 500 Pearl Street. He is with the Southern District. He's a New York federal judge. He's on a federal level. This is New York Southern District, the Southern District of New York. Apparently, there's an East District, the Southern District. Oy.
Well, there's also, you got to figure it out because there's 5 boroughs.
Right. Well, no. This is a federal court judge, and I'm going to try to go through this pretty quickly. So, with great respect, can you save your comments till I get the caller?
No, but go ahead.
Okay. Thank you. With great respect. So, we promised the prosecutors that we would get the litigation points on the record as quickly and easily and cleanly as possible. Are you still with me, caller?
Yes.
Okay. So in April of 2007, my mother, Ozana Radin, went down to talk with this is a federal district court judge, Judge Robert P. Patterson, Jr. She took a witness with her, and I'm going to ask you, can you just say who you are, caller?
My name is Ozana Radin, and Lidya Radin is my daughter, who is right now in the television.
Okay, thanks, Mom.
Okay, hon.
Now, my mother goes down my mother has a little accent, so I'm going to just say this very cutely. She wants to ask the judge a question. One question she should ask the judge. All right, I won't be cute anymore, right? So she goes down with a witness to talk to Judge Robert P. Patterson, Jr., and I'm going to, in order to make this as easy as possible, the evidence to be as accessible as possible, I'm going to ask my mother a series of questions. Mom, in order to support the timeline, in April 2007, did you go down to talk to Judge Patterson?
Yes.
Say yes loud.
Yes.
Talking to the phone so we can hear you. Say yes.
Yes.
Okay. I'm going to ask the question again. Did you go down to the district court to talk to Judge Patterson?
Yes.
Did you bring a witness with you?
Yes.
Who is that witness?
No. Let me do this, okay? Because I got to get through the points first, okay? So you went down to speak with Robert P. Patterson, Jr., the judge, Judge Patterson. You brought a witness with you. Did you identify yourself to Judge Patterson?
Yes.
Did you try to deceive him about your identity in any way?
No.
Did you say, my name is Ozana Radin?
Yes.
Did you say, my daughter's name is Lidya Radin?
Yes.
Were you in a disguise in any way?
No.
Were you incognito or trying to fool the judge or deceive him in any way?
No.
Did he invite you into his office?
Yes.
And his office is better known as his chambers. Is
Yes.
that, okay. I want you to think about the questions as I ask them. Did I put words in your mouth in any way?
No.
Am I pressuring you in any way?
No.
Thank you, Mrs. Radin. Judge Patterson I'm paraphrasing for you. Judge Patterson invited you into his office. Is that correct?
Yes.
Okay. When you were in his office, was it understood that this was not an ex parte communication? Just 1 second. And what I mean by an ex parte communication is that you were not trying to influence the judge without the other party being there. Is that correct?
Yes.
Okay. You were not trying to influence the judge. Is that
No.
correct? Okay. So he understood that this was not an ex parte communication.
Yes.
And you were there, you tried to explain to the judge to ask a single question.
Yes.
Okay. And you had my court papers with you because I gave you a brief that was from, I believe, October of 2006.
Yes.
You had a brief with you.
Yes.
Okay, wait till I finish the question, okay? Am I influencing you in any way?
No.
Okay. And you showed the court papers to the judge, and you said, Judge Patterson, these are my daughter's court papers. Yes?
Yes.
Okay. I'm not supposed to be leading the witness. So, did you show the judge the court papers from October? I think the brief was from October of 2006. I put them in your hands.
Yes.
Okay. And the single question that you wanted to ask the judge, and just wait and let me ask the question, was, Your Honor, everybody says that my daughter had a hearing before she was expelled from medical school. In fact, Dan Rizal, the attorney for the school at oral argument, claimed that I got 2 hearings before I was illegally expelled. So you went down and I said, if you'd like to, Ma, go ask the judge if he can show to you the written, published, faculty-approved hearing procedure that fully comports with the spirit of the law, that says I can be in the room to hear the testimony against me, the unsworn testimony, the false statements that my professors made. Go down and ask the judge to show you the written, published, faculty-approved hearing procedure that fully comports with the spirit of the law, that says a student can be in the room to hear the arguments and the witnesses against her. Okay? So you were going down to ask Judge Patterson, can I see the hearing procedure? Is that correct?
Correct.
Thank you. You're doing so good. Thank you. And could the judge show it to you? Are you there?
Yeah, I didn't hear you what you say now.
Okay. You go down and you're sitting in Judge Patterson's office, and you say, Your Honor, could I see the hearing procedure? Could you please show me the hearing procedure that my daughter got that fully comports with the spirit of the law?
Yeah, I heard that.
Okay. Could he show it to you?
No.
And you were trying to hold him accountable. Is that correct? You're trying
Yeah, I wanted to know why. Yes.
You were trying to hold him accountable, and you were trying to hold his feet to the fire. And you said to him, you can elaborate a little bit if you want. Could you please show me the hearing procedure? And did the judge say she should go tell your daughter to go down to the school and get it from the school? Did he say that?
Yes, correct.
Okay.
But he doesn't know. Yeah, he doesn't know. If he doesn't remember.
He doesn't know, he doesn't remember. He said that.
Tell my daughter to go to the school and yes for the hearing procedure.
He told you to go down to the school and ask the school for the hearing procedure?
That you should go down, and yes for the hearing procedure.
And you said, no, I want you to show it to me.
Yes.
And when he couldn't show it to you, he went and he got the marshals. Is that?
Yes.
And the marshals said if you didn't leave the office, they would arrest you?
Yeah, they go to put handcuffs on me and take me in.
They were going to put handcuffs on you and take you in?
Yes.
Now, Ma, are we against the marshals or do we like the marshals?
No, I'm not against Marshall. I'm not against anybody. I'm just telling the truth.
So, when a federal court judge couldn't show you the hearing procedure and said, tell your daughter to go to the school and get it, are we harassing anyone when we're following the direct instructions of a federal court judge?
Absolutely.
Absolutely what?
Correct.
No, I mean, were we harassing the school?
No, we did not harass. Exactly what the judge say.
The judge told us to contact the school and ask the school for a hearing procedure.
Absolutely, yes.
So when a federal district court judge says you go to the school, you get the hearing procedure, were we harassing anyone or did we have a legitimate purpose to contact the school?
A legitimate purpose.
A legitimate purpose?
Yes.
Are these your words or my?
No, that's my words.
So we had a legitimate purpose in contacting the school because a federal district court judge could not show you the hearing procedure and told you tell your daughter to contact the school directly. Is that your testimony?
Absolutely correct.
Now, Mrs. Radin,
Yes.
when you were in the judge's chambers, in any way did you make any kind of threat, implied or otherwise, that would deem it necessary for the law enforcement to be called?
No, he wants me to leave because he doesn't want to talk to me.
Okay, so no threats were made.
No threat was made of any kind. Only thing I want to do, please show me or tell me where my daughter got a hearing procedure. He says she couldn't.
He said that he couldn't show you the hearing procedure.
No, he doesn't know. He doesn't remember. I should leave. I said, please, can you tell me? He said no. In 2 seconds, the marshal was there. It didn't took not even a minute and a half. About
He doesn't
a minute and a
know.
half.
He doesn't remember. You should leave.
Yeah, and in a minute and a half, I didn't answer. When marshals came, I said, before I leave, I would like the judge to tell me why he testify against my daughter when he can't show me that.
The hearing procedure.
The hearing
well,
procedure.
Strictly speaking, a judge doesn't testify. I think what you're trying to say, and you'll please correct me if I'm wrong, I think what you're trying to say is, Your Honor, how can you rule against my daughter when you don't even have a written, published, faculty-approved hearing procedure that fully comports with the spirit?
That's right, and he answered that to me. I don't know. I don't remember.
I don't know. I don't remember.
Yeah.
Okay, and I think I had made motions like it wasn't like this was happening a long time. Oh, let me ask you this: how many times did you contact the judge?
Never.
No, I mean you're talking to this guy once, right?
Once. That's all.
Okay, so you talked to him once.
Once. That's the time. Only time that I contact him. I talk to him, and that was the only one.
Okay, so you don't email him, you don't phone him, you're not constantly going down to the court, right?
No.
Okay, I talked to Judge Patterson once. So in, I don't know, from 2004 to 2007, that's 3 years, we talked to the judge twice. I talked to him once after he ruled against me to let him know what he was doing was extremely dangerous. This is in 2005. And you talked to him once 2 years later. That is not harassment. Do you agree with me, Mrs. Radin?
Absolutely, yes.
Okay, and there was another point I wanted to make. he threatened to have you arrested, and then after that, I guess we're pretty much done.
He didn't threaten me. He called Marshall. Marshall says, if you don't leave, we will put the cuffs on you and escort you and take you in. Not escort you, take you in.
That we'll put the cuffs on you and that
we take you in.
So basically, they were trying to intimidate you to arrest you, and you were trying to hold your ground, and the only thing you wanted to do was have the answer to a single question.
That's all.
So, boy, that's some judge, huh? A federal district court judge who, by the way, happens to be ex-military, has a little old lady come to talk about her daughter and the welfare of other students, and all she asks the judge is, show me a piece of paper, and he's so scared he has to leave the room. He couldn't even face you like a man. Okay, I got to calm down now. Thank you. Is there anything you'd like to add?
No.
Okay. So we're going to let you go now, okay?
Okay.
All right.
Bye.
Mrs. Radin, thank you very much.
Oh, you're very welcome. Take care.
You too.
Bye-bye.
Bye.
That's cool. Now.
Wait, okay, go ahead.
No, I think she made a very valid point.
What was her point?
That, you do have, this is a legitimate case that should be followed, and that you're being roadblocked by judges like him, and that, your family's also being threatened with arrest.
My mother is doing this in the spirit of the grandmothers and mothers in Argentina. So when the big bad government I really have to calm down. When the big bad government in Argentina took men and women and murdered them, which is euphemistically referred to as the disappeared ones, and nobody should understand this better than all the Spanish people from South America, when they murdered their grandchildren and their children, it was the grandmothers and the mothers that went out into the plazas, I'm trying to calm down, on Sundays and held the government responsible. Where are my children? Where are my grandchildren? And the military and the corrupt government didn't dare lay a finger on little old ladies like my mother. My mother is not just fighting for my welfare. I was thrown out of school and stalked through life like an animal, almost murdered, and my mother went down to the federal district court judge and tried to tell him, you are violating these students' civil rights, and she was prepared to be arrested. Frankly, I think she should have been arrested. I critiqued my mother's performance, and I said, now, Mom, when the judge gets up and leaves the room, you chase him, and you temper it with a little humor, and you say, because Judge Patterson is like in his 70s or 80s, and my mother is about his contemporary. And you say to him, now, Judge Patterson, I know you think it's flattering to have a woman chase you, but at our age, it's a little ridiculous. So Judge Patterson was reacting to, and now I'm going to go through the documentary evidence. Oh, by the way, because it's 20 after 6, and I got about 40 minutes, and there's some documents I want to go through, because I am dedicating this show to Major Coyne. Major Coyne is an attorney. He is at the Pentagon, and he is legal counsel to the chairman of the Joint Chiefs of Staff. And I spoke to him before I came into the studio today. Oh, yes, it's Major Coyne. I tape recorded it. So Major Coyne says that he is, I'm paraphrasing, says that he thinks the federal district court judges he holds them in high regard. They've done nothing wrong. They lied. And I had law enforcement go through a few points. So what I want to do very quickly is dedicating this show to Major Coyne. Major Coyne, your confidence in federal district court judges, particularly Judge Patterson, is misplaced. And I'm going to show you 2 litigation points that I believe I talked to you on the phone, but you wanted to see them for your own eyes, so we're going to do that right now. So I don't have to do an exhaustive treatment In May of 2005, Judge Patterson ruled against me erroneously, wrongly. In June of 2005, 1 month later, I discovered an intentionally falsified promissory note that gave me the ability to amend my federal complaint based on newly discovered evidence in a 60B4 motion. So I'm going to give Major Coyne, yeah, that's his phone number. I was thinking of giving it out.
No.
I'm going to give Major Coyne 2 examples of how Judge Patterson lied. Okay, so we're going to look at that because we're going to look at, and by the way, law enforcement also, let me just, we're going to go to, hold on for just 1 second here. I got to expand this. Law enforcement asked me to make a timeline, support the timeline.
Bring it up a little.
Yeah, okay. And I was asked to do this as easily as possible. Try to do this, try to make it as easy to understand as possible. So here's what we're going to do. Here's an example of how Judge Patterson lied. Okay, this is, I'm going to go to our computer view here so you can see the page. You know what? Let me go down a little bit. Let me zoom out. Okay, here we go. Oops. Here we go. Okay, this is page 27 of Judge Patterson's May 2005 ruling. I'm going to start on page 26. Oh, let me come back to me for a minute. This, by the way, and we showed this to Judge Patterson, I hope you're horribly embarrassed in front of the marshals. This is your own police force. I went down to the marshals and said, hey, this is what was most recently submitted in the district court and in the Second Circuit Court of Appeals, and contained in this is the exhibits. This is Dan Rozelle. Dan Rozelle is the attorney who is paid by the school, and right here, thank you, Dan, he did me the great good favor of putting in as an exhibit Judge Patterson's May 2005 ruling against me. Do you see his opinion in order?
Yes, I do.
We showed this to Judge Patterson's own police, his own police force, which is basically the marshals, okay? So we showed this to the marshals. I hope you're horribly embarrassed in front of the marshals. We showed this to the marshals, and I wanted to give them just a couple examples of how Judge Patterson lied. So we go to page 26, right, and it says the amended complaint, page 26, okay? And now we're going to go to page 27. Do you see that?
Yes,
Okay,
I do.
hold that for me. So this is page 27, and we're going to read it, okay? So this is page 27, and now let me go to a view to, here we go. This is page 27. We're starting on page, I'm not lying or making anything up. It says the amended.
No, it's actually in black and white right in front of me.
Okay, so the amended complaint, it starts on page 26, the amended complaint, and now we're going to zoom in, and we're going to do this on a single sentence. Okay, and I'm going to make this as big as I possibly can so that there's no doubt in anybody's mind. Okay? Here we go. Is that big enough for everyone to see, or should I make it a little bigger? Let me make it
No, if you make it a little bigger, it's gonna.
Okay, here we go. Even if we run off I just want everybody to see it, because when it's on camera. Oh, that's a little too big. All right, let me go down a little bit. Okay, here we go. The amended complaint, however, identifies no bulletin, student guide, or compendium that allows a former student to correct ACOM's records. ACOM is the Albert Einstein College of Medicine of Yeshiva University, okay? I'm reading that. Do you see that, Mr.
Yes,
LeBeau?
I do.
Okay. So, the amended complaint, however, identifies no bulletin, student guide, or compendium that allows a former student to correct ACOM's records. That's a lie. How do we know that's a lie? Because this is page 22. Wait, I want to make sure I keep everything in order here. Okay, and I'll ask you to help me in just a second. Because this is page 22 of my college bulletin. Before I read this to you, and first of all, let me explain. I don't need a student policy, okay? It doesn't matter what the school's policy is. I have federal law. So the school's policy could be, we don't let students see their records. Who cares? Federal law trumps school policy. But in addition to federal law, the school's policy is to quote federal law. Okay, so we're going to look at the college's student records policy, which explicitly says the student records policy of the college is federal law. And this federal law is called FERPA, or Federal Education Rights and Privacy Act. And I'm going to put it up to show you. But before I do that, I want to thank Colonel Riley at Fort Knox. Colonel Riley was my friend in medical school. He still is my friend. And I went to visit him at Fort Knox, and while we were doing a whole bunch of other stuff, I said to him, Riley, while I'm here, I have my original college bulletin with me. Could you please confirm, authenticate that I'm not forging anything? This is page 22 of our college bulletin. And he did. Thank you, Colonel Riley. So we're going to look at page 22 of my college bulletin, and then I'm going to elaborate a little bit. By the way, I was threatened so much that, and Jersey City Medical Center knows this, I used to carry around that college bulletin like a prop. And if anybody would say anything to me about my false or delusional beliefs, I would whip out the college bulletin and confront them with it. Like Stacy Dix Kubiowski and the other dishonest doctors, and they would be backpedaling so fast you'd think they were going backwards. Hubbada, hubbada, hubbada. The judge lied. Let's look at it. Okay, so let me change the view. Okay, this is page 22 of my college bulletin. I had to get in my car and drive down to Fort Knox and talk to Riley. Okay, this is page 22. And the judge made up, actually when I talked to
That's good.
okay, so this is the, can everybody see this? I'm going to make it a little bigger. When I talked to attorneys, let me come back to me for a second. During the Sonia Sotomayor confirmation hearings in Washington, when Sonia Sotomayor they were considering whether they should confirm her for the Supreme Court. Sonia Sotomayor was one of 35 federal judges that I did an en banc procedure to. So at the federal district court level, you got Judge Patterson. He fabricated wholesale made-up rulings. I appealed to the Second Circuit Court of Appeals with 3 judges. The stupidity that they came up with, I'll comment on later shows. But when these 3 judges are overtly corrupt, what I could do is, and what I did, was an en banc procedure, which means you appeal to the entire Court of Appeals, all 35 judges, and you say, these 3 judges are bozos, could you please take a look at it? One of those 35 judges was Sonia Sotomayor. She now sits on the Supreme Court, okay? They made law that says a form, they fabricated it, they made it up, okay? Because I provided Judge Patterson and all the Second Circuit Court of Appeals judges with Code of Federal Regulations that defines a student as anyone who is or has been in attendance at an educational institution, okay? But let me go show you. I provided 35 copies of this, plus Judge Patterson. That's 36 federal judges, okay, who are sitting up there thinking to themselves, yeah, oh, Judge Patterson, he's a graduate of Columbia University Law School.
He should know better.
He's sitting up there going, yes, Miss Radin, as a graduate of Columbia University Law School, if my law school made a one-time honest mistake in my records, then I, as a former student, should not be allowed to access and correct them. What'd you do? Check your brain cells at the door? Okay. It's simple common sense. Your records are your property. I paid the fees that caused my records to be created and maintained. Just like when all of you out there in the viewing audience goes to a doctor, your medical records are your property because you paid the fees that caused those records to be created and maintained. So, as a Supreme Court issue, this is my property that I'm being denied access to. So let's go to Judge Patterson. Remember, we confirmed he came up with this bozo ruling that I could point to no college bulletin, compendium, or guide that would allow me as a former student to access and correct my records. And let's look at the school policy. So we're going to go to that right now. This is the school records policy, okay? First of all, I don't need school policy. I have federal law. And here's the, here we go. Here's the student records policy. Right here, student records policy. I'm going to make this even bigger. What I plan on doing is I'm going to make a copy of this tape and send it off to to Major Coin. He wants to be Colonel. To Major Coin. Here we go. This is a little too, okay. The student records policy of the college is designed to guarantee the rights of privacy and access as provided by the Family Education Rights and Privacy Act of 1974. Better known as the Buckley Amendment. This policy is consistent with the policies of Yeshiva University and applies to all medical school students, Let me read it again. The student records policy of the college is designed to guarantee the rights of privacy and access as provided by, this is the federal law, the name of the federal law is the Family Education Rights and Privacy Act of 1994. So the school records policy is federal law. Not only does federal law give me the right to fully access and correct my records, but the school's policy, as stated in my original college bulletin, is federal law. So, Mr. LeBeau, I'm trying to pick someone who doesn't, your average guy on the street.
You're saying I'm the average guy on the street?
No, you're extraordinarily not average because you're a hero and you're doing what very few people would do, which is to stand up to crime and corruption. And I'd probably be dead today if it wasn't for men like you. So you're a great big hero. You should get a commendation for this.
I don't need commendations.
So let me ask you, do you understand this?
Yeah, I understand this. And what I would like to say, I can't say on TV.
Okay. Well, we were asked to be professional. So
yes,
so we're
and not use certain types of language.
We're not going to use profanity. So
the only way to say it is, I think this is a huge, festering, steaming pile of horse hockey.
Okay, good. So, does it appear to you that the judge lied?
I think he did more than lie. I think he lied constantly.
I think he's bought. Is that what you're trying to say?
Well, I think he's in somebody's pocket.
When I went to Washington to talk to the Republican senators and I spoke directly to their attorneys, here's what they said. Judge Patterson didn't write this pile of garbage. It was written for him and he rubber stamped it because he's bought. Is that an accurate statement of how you feel?
I think it most eloquently states what's going on.
Okay, good. So now we're going to look at another example of how Judge Patterson lied. So, Major Coin, is this judge earning your respect or not? Because there's no respect for this judge. He needs to be removed from the bench, not just because he refuses to uphold federal law, but because he is cooperating with a medical school to steal money. My financial records are falsified. So let's look at that.
That's also defrauding the government.
Oh my goodness! Let's not even talk about how we're screwing the taxpayer, but that's a really good point because I talked to an expert at the state guarantee agency, the Higher Education Services Corporation. When you take out a federal loan, there's a state agency in Albany that monitors what's going on so students and taxpayers don't get ripped off. And that brings us to our next litigation point. And let's try to stay focused because Judge Patterson lied again. And here's what Judge Patterson said. And I knew he was going to do this. He claimed, now, one of the reasons I sued, I filed my complaint against the school in 2004, and in his wrong ruling, Judge Patterson said there was no breach of fiduciary duty. Now, fiduciary duty means that the school operates in a position of trust with its students, particularly when it manages money for them, okay? So putting all the federal loan issues aside, New York State gives students TAP grants. These are tuition assistance program grants. And the money does not go directly, I'm keeping an eye, oops. Okay. The money does not go directly from the state agency to the student, okay? The state does not send me a check. The money for the tuition or the tuition assistance program or the TAP program goes to the school. And the school is charged with managing these business accounts for the benefit of the student. In other words, they're managing money for you. They're operating in a position of trust with you. They, guess what, have a fiduciary duty. But that's for the state TAP program. So we'll put that aside for a moment. And by the way, I have that expert on audio tape, and I will be playing it. But now we're back into the federal student loan program because to stay on point, remember, Judge Patterson ruled against me in May of 2005. In June of 2005, 1 month later, I discovered the intentionally falsified promissory note in the federal student loan program or the Stafford program. And Judge Patterson said, oh, there is no breach of fiduciary duty, and he cites to a case called Moy. Okay, Moy cited to the wrong section of the Code of Federal Regulations. So let's look at Judge Patterson's page 27 of Judge Patterson's ruling. Here we go.
Now, by any chance, do you have that, Moy?
Yeah, I do. I have. Oh, no, believe me, I got more stuff that I know what to do with. Yes, I do. And
Moy.
Yeah, it's Moy versus. It's a case called Moy versus Adelphi. And I'll get to that in just 1 second. And the attorney who was handling this, here's Judge Patterson saying that there's no fiduciary duty. Okay, so this is, he claims that the only fiduciary duty is to see that the funds, there's no fiduciary duty between the student and the school and the rest of the folks in this. He claims there's no breach of fiduciary duty. The amended complaint alleges that this fiduciary duty was created through ACOM's administration of federal, the school's administration of financial aid programs in accordance with the Higher Education Act, okay? So he quotes Moy. And he says there's no fiduciary duty. There is. In fact, the word fiduciary is explicitly used. And this is what I read to the U.S. Marshals, and I'm going to show you. The school, as a fiduciary, the word fiduciary is explicitly used. The school, as a fiduciary, for the benefit of the guarantee agency, the secretary, and the student. Excuse me. This is the Code of Federal Regulations for the administration of federal student loan program, and the word fiduciary is explicitly used. All right? But do we need to have this law? No. I mean, it's blatantly obvious that students should be able to trust their professors. To say anything otherwise puts a chilling effect on the student-teacher relationship.
More than their professors, they have to be able to trust the school.
Oh, everybody in you have different.
The entire governing body of the school has to be trusted. Otherwise, they shouldn't be accredited.
Accredited, they should be shut down. This is a school that lies to steal money from their students, and they purport to be a religious institution. Thou shalt not steal, Rabbi Lamb. I'll go to every rabbi. So, in any case, let's look at the Code of Federal Regulations. And again, we show this to your own marshals, Judge Patterson. I hope you're ashamed every time you walk. Don't tell me to be nice. I hope, Judge Patterson, that you are ashamed every single time that you walk in and out of 500 Pearl Street, where your courthouse is, and you have to look those marshals in the eye, and they know you're a liar, that you helped the medical school lie to steal money from students. But even more than that, what you have done is unconscionable. To allow students to be expelled from medical school without a fair hearing, to fabricate rulings, to create a body of law that says students can't access and correct their records so they can lie about a student's past is very frightening. You don't understand how dangerous this man is.
No, I believe me, I understand.
You leave a school, and the school, like my school, lies about your past. Oh, come on. So that's unbelievable. I had to call the United States Air Force Academy in Colorado Springs, where Mr. Mikey Weinstein operates, and get commitments from them that they would educate their cadets. So one day in the future, when those young men and women are in their 30s, 40s, and 50s, and they speak truth to power, like Mr. Mikey Weinstein's friend spoke truth to power, that their schools could not go back and lie about their past. And he knows exactly what I'm talking about, because I grew up with this, okay? Richard Nixon is on the television swearing to God there's no war in Cambodia, and my friends were marching through Cambodia. The government lies. So you have to teach those cadets and their families how to protect themselves against a government who lies, and we're demonstrating it for you, okay? So now we're going to go to the Code of Federal Regulations and look at that statute, okay? And we're going to zoom in. I mean, it's not freaking rocket science. And here we go. Moy quoted the wrong section of the Code of Federal Regulations.
Now, which section did they quote?
It doesn't matter. They quoted the wrong section. I'll get to that later, because we only got about 20 minutes left in this program. And I want to show how Dan Rizal lied. Whoops. Sorry. All right. Thank you for your patience and understanding while I pull this up. Okay, here we go. This is the correct. All of this was submitted in federal court. Okay, there's no excuses here. Okay. Here we go. Thus, is that big enough? Or maybe I should make it even bigger.
No, that's big enough.
No, wait. Here we go. Now it's undeniable. Okay? No, and by the way, okay, here we go. The school, as a fiduciary for the benefit of the guarantee agency, the secretary, and the student. Okay, what doesn't the judge understand? The school, as a fiduciary operating in a position of trust, managing money and business accounts for the benefit of the guarantee agency. This is a state guarantee agency, the Higher Education Services Corporation. Congressman Joseph Crowley wrote me and another student a letter of introduction to this agency. The school, as a fiduciary for the benefit of the guarantee agency, the secretary, this is the United States Secretary of Education, that would be Margaret Spellings, who I spoke to personally several times, and the student. The school, as a fiduciary operating in a position of trust for the benefit of the guarantee agency, the secretary, and the student. There is a fiduciary duty. It's not rocket science. Judge Patterson lied. What don't you understand, Major Coyne? Do you think any other reports coming out of this school are any more honest than the false statements of material fact and the false statements I'm showing you? This school lies. This judge lies. Okay, now, what is my mother reacting to? Because I got about 15 minutes, and I certainly want to make sure this is good for Major Coyne, and then I want to thank a few people. What is my mother reacting to? This right here, because this was a timeline. Wait, let me do this. This is a timeline. Thank you. See this? This is from 2005. I'm going to pull this up. And this is a transcript of oral argument. So Dan Rozelle comes into court, and he's going to do oral argument in 2005. Now, I filed my case in 2004. I was forced to fire my attorney and hire a new attorney, so that delayed everything for a few months. Then I filed my case in 2004, and we go into oral argument in 2005. And Dan Rozelle of Sive, Paget, and Rozelle, and you should know these attorneys because at Pace Law School, Mr. Sive is, I think it's Sive, Paget, and Rozelle. Yes, Sive is a, if you go to the Pace Law School Library, they've dedicated like a portion, I think it's Sive, of their library to him because he was the father of environmental law. So this is the law firm that Dan Rozelle works for as a partner of, Sive, Paget, and Rozelle. I'm going to go to, this is a transcript of oral argument in 2005. Remember, I was asked by law enforcement to come up with a timeline. And here's where Dan Rozelle says, before I was expelled from medical school, that, can you see this? Is this big enough for you to see on the monitor, or should I go?
No, that's good.
I want to make sure there's no doubt in anybody's, because you're looking here, they have to read.
I'm looking at the paper.
Okay. Here's what Dan says as he's talking to Judge Patterson. There were at least 2 hearings with plaintiff, that's me, represented by counsel at least one of them. There were at least 2 hearings. That's a lie. The first meeting that the promotions committee had to expel me, I was excluded. I had to call the president of the American Medical Students Association, and she made phone calls. It was only after she made phone calls, and I had to go to my United States senator, and I had to put up a big fuss, that finally there was another meeting of the promotions committee, and that was not a hearing. Dan Rozelle was forced to admit that, okay, there weren't 2 hearings, there was 1. No, there were no hearings. That's why my mother went down and asked Judge Patterson, can you please show me the written, published, faculty-approved hearing procedure that fully comports with the spirit of the law that says my daughter had the right to be in the room to hear the arguments against her. What a concept, okay? They can't. So the purpose, this is happening in 2005, and the purpose of my, this is happening in 2005, and the purpose of my criminal trial in 2010 was for Judge McLaughlin in the criminal court to make up, to fabricate that, oh, there was a psychiatric event, therefore they followed the proper policy. There wasn't. Judge McLaughlin is willing to say on the record, Judge McLaughlin is a liar, and we'll get to him right now. You know something? I'll give you 1 point right now so you know Judge McLaughlin is a liar. I presented, when I was fighting this fight in Jersey City with Judge Rodriguez, this is the municipal court judge, I said, you know, Judge Rodriguez, you can't, in effect, and it was Judge Rodriguez, Judge Morena, there was another judge, and there was Judge Ray Velasquez, who is now City Councilman Ray Velasquez. When I was living in Jersey and I'm fighting against my landlords in the city court, I said, look, all of this comes down to is my school is lying. One of the things that they're doing is they're lying to steal money. And here's case law. I gave them case law that says, here's a pro se litigant with a municipal court judge who is and this is happening in New York, so this is case law in New York. I gave all these judges in the city court, here's case law that shows a pro se litigant like me with a municipal court judge, a city judge, went to this judge and said, the school is lying to steal money, I'm not paying for this, and the municipal court judge enforced federal law. Okay? Is that hard for you to follow?
Not at all.
Judge McLaughlin lied, and he's talking to people who don't know better, and he's like, oh, state judges enforce state law. They can't enforce federal law. Only federal judges can enforce federal law. He's a liar, okay? I presented case law that shows a city court judge can enforce the federal statutes regarding federal student loans. That judge found fraud and didn't make that student pay for classes, services that student never got. And Judge Rodriguez in Jersey City refused to uphold the law, and the purpose of my criminal trial was to create a false record so the school could escape accountability. Do you follow me?
Mm-hmm.
Okay, so now we're going to go back to 2005. Dan Rizal at oral argument claims there were 2 hearings. He lied. Okay? And the reason my mother went to talk to him was, well, if my daughter got a hearing, can you show me the hearing procedure? There wasn't any. Judge Patterson told me and my family, go down and contact the school. So when I go down and contact the school in 2007 and 2008 and 2009, because one of the people who told me to do that was a federal district court judge, that's not harassment. I had and I continue to have a legitimate purpose in seeking to access and correct my records. And even now, even today, I have not gotten my complete unedited records, and they've held records back from me which show that I'm telling the truth and the school lied. So in 2005, I've got 5 minutes to put 2 more examples out there. In 2005, Dan Rizal says there are at least 2 hearings. In 2006, Marlene Abramova goes into federal court, and she starts getting admissions of guilt. She could have won her case, but for the fact that she stabbed me in the back. And one of the reason why other students were calling me, and they were building their case on mine, is because I'm saying, none of us got a hearing. We were all required to be out in the hall while in a meeting room. Our professors gave false, unsworn testimony against us, okay? And she was kicked out of school because they claimed she was cheating and it was a disciplinary problem, right? Mm-hmm. The tragedy is she didn't cheat. She can prove she didn't cheat. She was picked on because they needed cover. They had to throw a woman out of anatomy lab for cheating because Robin Patton was the cheater. She was my anatomy partner and Kevin Riley's anatomy partner. She concocted a scheme to cheat. The school gave her a medical degree, and now they had to create cover. So they had to find someone to kick out. So they manipulated Marlene, and she's such an idiot. So here's the deal. 2005, 2 hearings. I'm named as a witness in the Marlene Abramova case, and I'm educating her attorneys, and I'm telling them what to do, and I'm like, look, I'm an expert in this. I know what these guys are going to do, and she starts getting admissions of guilt. Let's look at those admissions of guilt, shall we? Okay, this is from the Marlene Abramova case. And from this case, here's her admissions of guilt. The school's attorneys are reacting to her complaint. And it says, you see here, paragraph 55, they admit that ACOM, Albert Einstein College of Medicine, ACOM's internal rules do not permit students to cross-examine witnesses at student disciplinary hearings. Okay? If you can't cross-examine witnesses, it's not a hearing. Is that rocket science to you?
Astrophysics.
I mean, come on, that's ridiculous. Let's look at the other admission of guilt. Okay? And this is paragraph 56. Admit that ACOM's internal rules do not contemplate the preparation of a transcript of the proceedings. Okay? Now,
so in other words, what they're saying is they don't think they're going to need a transcript?
No, that's not. It's not a matter of whether you need a transcript or not. Is that the first line of defense when you go to sue the school? It's called an Article 78 defense, and it has a 4-month statute of limitations. So the strategy from the school is if we just delay for 4 months, then the student will have blown the statute of limitations. They try to play you. They prey on your ignorance. So the bottom line is the only thing a judge can do in an Article 78 review, and I can do this very quickly, is there are a lot of agencies in New York. You know, there's public housing, there's the police department, there's all kinds of agencies. I'm going quickly. I'm watching the time. there's all kinds of agencies. Now, we're not supposed to clog the courts. The courts have better things to do. So what we're supposed to do is follow the internal rules. So if you're a police officer, for example, and they're trying to fire you, there's supposed to be some fair hearing procedure that you go to before you complain to the courts. If you're living in public housing and they're trying to get you out of your apartment for, bogus reasons, there's supposed to be some hearing procedure. So the first thing, if you're wronged, the first thing you're supposed to do is ask for an Article 78 review. And the agency involved has a responsibility to give you a final determination, and they're supposed to say, if you disagree with this, you can do an Article 78 review. Strictly speaking, they don't have to tell you that it's a 4-month statute of limitations, but as a courtesy, they usually should, because you're dealing with, the general public, and it's not fair to prey on people's ignorance. So what a judge is supposed to do in an Article 78 review, he's supposed to say, well, here's the written, published, faculty-approved hearing procedure. I got that. And that's in one hand. And here's the certified verbatim transcript of the hearing. I got that in another hand. So he's supposed to read and say, okay, so this was supposed to happen, and I see in the certified verbatim transcript that happened. So I'm looking and I see, oh yes, this is the procedure, and I see that happened. So the only thing that happens in an Article 78 review is that in one hand, the judge has the hearing procedure, and in another hand, the judge has a certified verbatim transcript. Without a certified verbatim transcript, what is the judge going to review? Air? Okay? So without a certified verbatim transcript, there can be no judicial Article 78 judicial review. So now the school knows that they're caught. They have no first line of defense. Are you listening up, Major Coin over there at the Pentagon? There is no first line of defense. So now they have to start making stuff up. So now they go into the law books and they say, okay, even without a certified verbatim transcript, we could still do an Article 78. No, you can't, because you don't even have a written, published, faculty-approved hearing procedure. Okay, they're liars. They just make stuff up. In my case, they claimed that I was a student with a psychiatric illness. I'm not. And even if you look at the school's policy, it doesn't say that the student has the right to be in the room to hear the arguments against her. So basically, and that's the admissions of guilt that we have here. In the Marlene Abramova case, it's admitted. Now, she's being expelled because they claim that she cheated. And they're claiming she can't even be in the room. They're admitting that she can't be in the room to cross-examine witnesses. If you can't cross-examine witnesses, you don't have a hearing. Okay, and basically what the school does is they've engineered out of everything they do the rights of the accused. So a false accusation is enough to destroy an innocent person's life. This is huge. Okay, this is why I went to Mel Goldberg. He was an attorney that I was referred to at the Andrew Cuomo's State Attorney General's office, and he said, Lydia, what are the policies at the other schools? And that's why I did the legwork for free for him for 3 days. And what I discovered is there has never been a hearing for a medical school student in the state of New York since the dawn of time. It is unconscionable. Violating the rights of civil liberties of medical school students is huge. Okay, so let's just go back really quick and look at this. They admit that ACOM's, the Albert Einstein College of Medicine's, internal rules do not permit students to cross-examine witnesses. Okay, there's no cross-examination, there is no hearing. And they admit that ACOM, the Albert Einstein College of Medicine, internal rules do not contemplate the preparation of a transcript of the proceedings. We got about 2 minutes left. Was that good?
Yeah, but you gotta
I know.
speed it up a little. You gotta keep watching the time.